Thank you so much for joining us for another edition of All Angles. I'm Dion Jacksmill, and a very special welcome to our viewers on OneSpotMedia.com. Well, the Industrial Disputes Tribunal today handed down, well, not today, earlier this week I should say, handed down its ruling in the case of the former Human Resources Manager of PETROJAM who had been dismissed. More on that in just a little while. But of course, the IDT has been the subject of a lot of talk over the past few days, few weeks, following a revelation from PETROJAM that it had decided to pay out a settlement agreement to another former HR manager rather than go to the IDT, which it said was employee-centric. Is this really the case? We're going to be looking at those issues this evening, and we have with us attorney at law Emil Leiber. We also have with us the president of the Jamaica Employers Federation, David Wan, and president of the University and Allied Workers Union, Lambert Brown. Just before we go to our guests, though, let's go to this overview.
Rosalie Scott Heron and Yolande Ramharak have something in common. At some point, they had been the Human Resource Development and Administration Manager at PETROJAM. Mrs. Scott Heron was fired and just won her wrongful dismissal case at the Industrial Disputes Tribunal, IDT. She is to be paid $9.82 million for 1 year's salary. Ms. Ramharak agreed to walk away from the lucrative job when both parties agreed on a $10.2 million settlement. Other termination entitlements brought the total to $13.2 million.
How do you explain this 60% chance of her being successful, which you have used in the calculation, even though procedurally PETROJAM was impeccable, and in terms of the 19 charges, on multiple of those 19, almost all 19, were the basis for dismissal for cause and without any further payment and without notice.
The legal advice was that the IDT is very employee-centric. There is almost a bias towards the employee, and even the slightest procedural breach can tip the scales in favor of the employee. This is legal advice that we obtained from a reputable and established counsel.
That was PETROJAM's legal officer Tamara Robinson explaining to Parliament's Public Accounts Committee PAC why PETROJAM paid Ms. Ramharak and avoided the IDT. Prime Minister Andrew Holness doubled down on the logic as well.
The board, in doing the assessment, made a determination that it would have ended up far more expensive. And if, as was being suggested, that you could summarily terminate, you still would have to impute in the cost-benefit analysis what would be the risk of being taken before the court and what would be the potential charges.
The notions of IDT bias against employers had the powerful trilogy of the Private Sector Organization of Jamaica, Jamaica Manufacturers and Exporters Association, and the Jamaica Chamber of Commerce lamenting the rulings against the employers. The three want the labor code to be revamped, arguing that the IDT's rulings are unfairly being made based on the inequitable and one-sided concentration of strict application of the code procedures and not on the substantive facts of the offense. They also raised the high cost associated with bringing cases to the Industrial Disputes Tribunal. But head of the Hugh Shearer Labour Studies Institute, Danny Roberts, told the Gleaner last week that whenever the IDT overturns a decision, it's usually when the employer has failed to follow due process. It's called vigilante justice.
Okay, so the net effect there is that Mrs. Scott Heron, who was dismissed without cause, without reason, without notice, in a manner that the IDT called unfair, unreasonable, and unjustifiable, ended up getting a 12-month compensation award, while the HR manager, who was facing 19 serious disciplinary charges, got 8 months plus. Now, before we go on, though, I think I need to correct an error in that I take full responsibility for the issue of wrongful dismissal vis-a-vis unfair dismissal. And since I have Emil Leiber here, I'll just ask him, in fact, to do the honors, because we're talking about one before the court, one before the IDT, correct?
That's correct, Dion. Wrongful dismissal is basically when somebody goes to court and says that the four corners of their contract have not been complied with, usually in the context of the notice clause in the contract. So wrongful dismissal is something that really a court would consider, rather than unjustifiable dismissal really is what is used in the context of the Industrial Disputes Tribunal. Because when an employee's contract of employment is terminated, they have two avenues open to them. They can either go to a court to have a judge determine their matter, or they can go to the Industrial Disputes Tribunal.
Which is better?
Well, are you asking for the employer or the employee?
Well, let's put it in the context of the fact that the IDT is supposed to be, as was described by the Privy Council in that recent ruling, a forum that was supposed to be for settlement of disputes, right?
Yes,
not
indeed.
for adjudication of claims per se. But
well, let me put it this way. The IDT, under the Labor Relations and Industrial Disputes Act, they have the power to order reinstatement, which is a significant power that the court does not have. The IDT also has the power to inquire into the process, to basically look behind the mechanism that you use to terminate. Now, a court is bound by the four corners of the contract. It's a court of law. So the court, if a matter is brought to the court will say, okay, did you comply with the terms of the contract? Did you give notice? Was this a situation of summary dismissal where you could terminate without notice? So the court will look at the four corners of the contract and make a determination. But the IDT's remit is much broader. The IDT...
And they can make larger awards.
Yes, they certainly have the competence and the legislative power to make much larger awards than would flow from a court action.
So therefore, if I'm a worker, I'm going IDT.
99.9% of the time, yes.
And David, is that good or bad for you as the employer side?
Well, naturally, puts us at a disadvantage.
How?
Because, that's
if the dismissal was justified. And I say Lammy gearing up.
Well, as Emil has pointed out, the IDT has the power to make much larger awards. So it's disadvantageous to the employers.
Shouldn't that be incentive to do the thing properly, though?
Of course it should be, but we're not saying that, there are some employers who, don't follow the process. There are some like that.
Or wholly?
I can't give you that figure. But listen, Dion, before we go any further,
yes.
I just want to clarify one thing, which is of a general nature. We are not in the private sector trying to diminish anybody's rights in the workplace. What we're trying to do is to fix the dispute resolution process, which is heavily skewed against employers. We're not trying to reduce anybody's rights.
That's the exact point of dispute, though, because I suspect...
Well, I want to say that, whether there's a different view. We're not trying to reduce anybody's rights to a disciplinary hearing, rights to appeal, rights to representation. We're not trying to touch any of those.
But when you when you object to decisions being made on procedural grounds, meaning a proper hearing was not held, there were flaws in the process that led to the dismissal of the work, and you're saying, just look at what we're saying they did or didn't do.
No, that's not quite right, what we're saying. What we're saying is, if there was a clear case where the employee would have been justifiably discharged, save and except a part of the process wasn't followed, in those instances, why don't you assess a penalty and a fine against the employer, but much smaller than is now being awarded when there's a clear case for dismissal, save and except a part of the process wasn't followed?
All right, we're going to come back to that. Lambert Brown, let me bring you in here because you have said you don't agree.
Absolutely.
That is employee-centric, but then you also represent employees. So don't you have a vested interest in saying that?
I have a vested interest in speaking the truth and stating facts.
Sometimes it's perspective, not necessarily truth or
Well,
lie.
you can make the judgment and your viewers can make the judgment. Let me give you an example. We're told that the IDT makes bigger award than the courts. There's a case in court right now, Marilyn Hamilton versus UGI Insurance Company. She was fired in 2006 before individual workers were re-allowed to take their cases to the IDT. the courts have awarded her millions of dollars. 3 years pay up to her retirement. That's 2006. That case is still before the courts because the employer appealed it and has tried every procedural measures they can before it got to be heard. It was supposed to have been heard last year, May. 13 years now, she can't get justice. And we're waiting for that decision of the Court of Appeal. That's bigger than most of the judgment. There's a case that the IDT did, just for David thing. Donald Benjamin. I looked at it on the court, on the Supreme Court website today. She was found unjustifiably dismissed because the company didn't follow the proper procedure, didn't put the allegation in writing, as the court said. They offered her $20,000.
In which year?
About 2011 or so.
Okay.
So $20,000. That's probably 2 weeks or 3 weeks pay. So this notion that the IDT gives big award and bigger is not based on facts. There's a case of a guy named Garrett Francis, private power. It's all decided in the court in 2012.
Isn't one of
They
the
found him
issues-
unjustified dismissed. The tribunal awarded 2 weeks pay. His union challenged the tribunal 2 weeks pay in court. And the court said, no man, the tribunal have a right to decide whatever they want to give. That's what the parliament gave the power to the tribunal to do. So this notion that it's a runaway train, it's a monster, and it's out of sync is not in keeping with the reality. The IDT is being over-criticized by people who don't know what is happening at the IDT.
Well, hold
And
that
I said
thought.
this there.
Hold that thought.
All
Matt
of these
Break.
cases are on the Jamaica Supreme Court website.
Hold that thought, though, because we're going to go to our first break and we'll come back in just a moment. Remember, you can tweet along with us. Our hashtag is TVJ. All angles soon come.